Hi, besties! Welcome back to my channel. Blake Lively and the Wayfair parties have officially been ordered by the court into a settlement conference, and this is not optional. This is now a court order, and failure to participate or meaningfully engage in the settlement process can result in contempt of court. As of today, both sides are required, through their attorneys, to appear on December 15th for a video conference with Magistrate Judge Sarah Cave. That meeting is not the settlement itself, it's a scheduling and logistics conference, where the judge will determine the format, timeline, and availability for the actual settlement conference, whether it will be in person, by phone, or via video. Once Judge Cave gathers availability from both sides, she will propose dates, and because this is now an order, everyone must participate. Now, let's clear up some misinformation I'm seeing online. Settlement conferences are not mandatory in every federal case, and they are not automatically required in New York. The Southern District of New York does not have a rule forcing all cases into settlement. Instead, settlement conferences are used strategically, especially in high-conflict civil cases where the parties are completely entrenched and are placing a significant burden on the court. High-conflict cases drain judicial resources. They generate constant motions, discovery disputes, sealing fights, and emergency filings. When that happens, judges often step in and say, "Enough, let's see if this can be resolved." Now, settlement does not mean someone walks in and demands a massive payout. That's not how this works. In this case, the settlement will be overseen by a magistrate judge who acts as a neutral third party. Her role is not to take sides, it's to help both parties realistically assess risk, weaknesses, exposure, and possible outcomes if this case proceeds to trial. I've personally been through settlement conferences, and you can walk in saying, "I'll never settle." But these judges are extremely skilled at managing high-conflict personalities. They are very good at explaining, calmly and clearly, where a case may fall apart at trial, and what public exposure actually looks like once a case leaves the sealed record and enters a courtroom. And that matters here. Once you go to trial, everything becomes fair game. Finances, communications, personal relationships. There's no hiding behind sealing motions anymore. And in this case, Blake's side has relied heavily on sealing. In my experience, settlement conferences often involve joint sessions followed by private breakout rooms, where each side meets separately with the judge. The judge then moves back and forth, communicating concerns, risks, and potential resolutions. No one is forced to settle, but options are laid out clearly. Importantly, settlements do not require apologies, ever. An apology is an admission of liability, and no magistrate will demand one. Blake and Ryan will never apologize, not in settlement, and not even if they lost at trial. What you might see instead is carefully worded language about misunderstandings, stress, or misinterpretations, statements that resolve the dispute without admitting wrongdoing. Settlement also does not have to involve money. In my own case, no money changed hands. No attorney's fees were paid. Everyone simply walked away. And while that can feel unsatisfying emotionally, it's extremely common under the American rule, where each party pays their own legal fees unless damages are proven. Here, no judge is going to force Wayfair to give up rights to a film, pay damages that aren't supported, or rewrite history. But leverage exists on both sides. For example, Wayfair could agree not to pursue malicious prosecution or appeals in exchange for Blake walking away without compensation. That's how leverage works in federal civil litigation. Based on what we're seeing right now, the party with the strongest leverage going into settlement is Justin Baldoni and Wayfair, and that's because of recent evidentiary admissions. In Blake Lively's response to the court's Rule 56.1 undisputed facts, she makes a critical admission. Paragraph 42 states, undisputed, that Ryan Reynolds wrote the revisions to the rooftop scene that Blake proposed. That matters a lot, because it directly undermines earlier claims about authorship, control, and creative interference. And once something is admitted as undisputed, it becomes extremely difficult to walk back. So now this case is officially in the settlement phase, not because the court believes everyone will agree, but because the court believes the risks of continuing may outweigh the benefits. Whether this settles or not remains to be seen, but what's clear is this: the court has lost patience, the record is expanding, and the pressure is very real. The 5 points leading up to this all centered on one thing: the pressure Blake Lively applied to force acceptance of her revisions to the rooftop scene. She repeatedly pushed those changes, leaned on her personal relationships, specifically Taylor Swift and her husband Ryan Reynolds, and sent text messages framing the revisions as her work. At no point did she disclose that Ryan was actually writing those changes. That matters, because it wasn't a misunderstanding, it was a misrepresentation. She affirmatively represented that the writing was hers, when in reality it came from her husband. And that kind of lie can unravel an entire case. Once a plaintiff admits to lying about a material fact, credibility becomes a serious problem. If Blake were to take the witness stand, the defense could point to her own sworn admissions. A judge could even instruct the jury to treat her testimony with skepticism, because she has already acknowledged lying in official filings. That's devastating in any case, especially one built on credibility. And it doesn't stop there. If she lied about authorship and creative control, it raises a much bigger question. What else did she lie about? Another major hurdle she would face at trial is proving that Wayfair's actions constituted a smear campaign rather than a response to what she and Ryan were doing publicly. Because here's another admission they made, one they previously denied. They now admit to planting negative stories about Baldoni. They admit that Leslie Sloan placed an article portraying Baldoni as abusive and chauvinistic. They admit that the August 9th Daily Mail article accusing him of misogyny and creative obstruction was planted by their side. That article wasn't about safety or harassment, it was about creative control. So how do you stand in front of a jury and claim reputational damages when you were actively damaging the other party's reputation in the media? That gives Wayfair a clear defense. They weren't attacking, they were responding. They've also admitted to misusing the legal system. The Van Zandt lawsuit was filed not because it had merit, but to obtain materials that were then quietly handed to the New York Times without notifying the opposing side. And the so-called evidence of a smear campaign, like the Shasti Flaw Little Bump video, Blake now admits she has no evidence tying that to the defendants. Same with the claim that Baldoni previously conspired with the New York Times to plant stories about her in August 2024. Again, undisputed that there's no evidence. What's also undisputed is that Baldoni had nothing to do with the negative articles written about Blake. So whether the judge has read every page or not, their clerks certainly have, and they're likely flagging the same issues: repeated admissions of lying, admissions of planting stories, admissions that her husband was involved, and admissions that this wasn't solely about her, it was about a coordinated effort involving Ryan Reynolds. At that point, the case stops looking like sexual harassment and starts looking exactly like what Wayfair has argued all along: an attempted hostile takeover of a film. That's why Blake has a strong incentive to settle. A public trial would be humiliating, and the damage to both her and Ryan's careers would be permanent if it hasn't already happened. Blake may never work again simply because of the liability she now represents. And frankly, Ryan's reputation isn't much better. We've seen this before. Amber Heard went to trial, lost, and her career effectively vanished. Even after losing, she doubled down instead of taking accountability. If Blake follows the same path, the outcome could be even worse. A skilled magistrate judge could likely make that clear to both Blake and Ryan, that they don't have the evidence they think they do, and that trial would be catastrophic. A resolution might involve no apology, no admission of fault, but a carefully crafted statement and a mutual agreement to move on. Is that fair? Probably not. Does it absolve them legally? Maybe. But in the court of public opinion, the damage is already done. So what do you think? Let me know in the comments below. If you found this breakdown helpful, give the video a thumbs up, subscribe if you haven't already, and click the bell so you don't miss future updates. Thanks so much for watching. Bye, bestie!